Welcome everybody. Thanks for joining us. Hopefully we can address some of the frustration, the confusion and the impatience, maybe not the impatience, that might be out of our control, but we will be chatting all things Employment Rights Bill and updating you on where we are with it all, for the moment at least, until maybe next week when things may change again. But it's useful to be tracking where we're going with all of this. So for those of you that don't know me, I'm Nick and I head the employment team at Actons. We're based in Nottingham and we work with clients across the UK. James is with me and he'll introduce himself at the point he gets to his slides and say hi, but it's really great that you could join us. The team comprises currently a few more of us. As I say, Laura is not with us today because she's very fortunate to be at the F1 for the weekend. But do connect with us on LinkedIn. So you can pop your smartphone out and using your camera, you can scan that QR code and connect with the team on LinkedIn. We're pretty active on LinkedIn with a newsletter with lots of updates. And even if you don't use LinkedIn, I would suggest it's a good place to actually keep up to date with all that's going on with the Employment Rights Bill and other developments in employment law, even if you just drop in every now and again just to check in on the people that you follow that you know are sharing updates. It's definitely worth doing that and a good way of keeping up to date. So do feel free to connect with us if you're not already. I know a lot of people are. And of course, we're working with a lot of employers at the minute on the UK employment law reform, as that slide refers to it as. There is lots changing. There's lots still to be confirmed. It is confusing. It is frustrating, but there are certain things that we can be pretty sure of the direction of travel on, and therefore it's possible to plan for some of the stuff that's coming already and be focusing on certain things. We're going to try and give some of that practical insight as part of this session, but obviously if you're looking for specific support in certain areas, we'd be really happy to help, and do reach out to us. One of the other things that I'd just like to plug as part of our webinars, for those of you that have been on before, you know that we do this every time. I have the pleasure of hosting a podcast called the HRD Talks podcast, and the latest episode was released, I think, just last month with Sharon. She is an excellent guest, talks very commercially about HR. And of course, that's one of the things that HR professionals in particular are being criticised for a bit in the media at the minute. And she talks a little bit about that and a bit about how the HR profession can be more commercial. So do check that out. You can do that at our website, which it has the address there on the slide, or in fact, your favourite podcast provider, it will be there. It's pretty much everywhere. So do check that out. In terms of today, James and I are going to chop and change a bit in terms of presenting, and that's partly so you don't get bored of hearing one of our voices all of the time, but partly because there's a lot of different subjects that this bill covers. I think there's probably 28 or so different areas that it's impacting on. So we've got quite a bit to cover. We're highlighting the majority of the key provisions as we see them. We're not going to go into masses and masses of detail on every single one, but it certainly will be enough for you to know what's coming and to start planning for that. We're going to look at the updated timeline. So when is all of this stuff coming? And there may be some change to that. We'll delve into that. We're going to highlight particularly unfair dismissal changes, and anybody who was watching the national press this week and last will have seen some interesting developments there. James is going to talk to us about fire and rehire, which we are talking to lots of clients about because it's kind of the area that we think clients are missing a bit, and James will explain more on that. And then we're going to canter through chopping and changing in terms of areas a little bit, and also presenters when it comes to the other provisions that are in the bill and what we would like to highlight on each of those. So it'll be a bit of a whistle-stop tour, hopefully useful. We will have time for questions at the end, but we also, as you've seen already, are very happy with us using the chat function as we go. So if you have a question now, even feel free to pop it in there. The luxury of James and I both presenting is that while the other one's talking, we can be looking at the questions there. And either we can pick them up at the end or we can pick them up as we go. So do feel free to both say hi and to ask any questions in the chat as we go along. So let's get into some of the detail. So the timeline, if you haven't seen those two documents, it is worth a read of both of them. I wouldn't recommend reading the bill itself. It's very long and it lacks so much detail that a lot of it is not actually very easy to follow. But these two documents are much more digestible in their content, and they very much cover things in a headline fashion in a way that sets, I think, the direction that the government are going with this. And obviously, there's been developments along the way, and you know, different people have a different view on how well the government have managed this process in terms of the way that it's being implemented. But those documents are certainly worth a read if you're interested in why is this happening, what are the government actually looking to do, and when. And some of that detail obviously we'll be covering in the next few slides. So obviously the current position in the timeline is helpful to look at. And basically, we're nearing the end, you'll be pleased to hear, in terms of the implementation of the bill and it turning into an act, so it becoming an act of Parliament. And it's kind of been what's been described as ping-ponging between the House of Commons and the House of Lords for a little while now, with the Lords looking to make amendments to what the government had proposed as part of the bill, bouncing it back and saying, we don't like that, or we don't agree with that, we think we can do it differently. And there's one key development that we'll talk about on that front, very much kind of pushed by the House of Lords. But it's due to go back to the House of Commons again, hopefully for a final time. We're not entirely sure, but we'll see, on the 8th of December. And there is some more detail, we assume, coming pretty soon as to the details of the government's latest proposals with regards to the amendments that are being kind of ping-ponged back and forth. Obviously, we had hoped that the bill would become law in 2025. I think most people are now thinking there's not that long before Christmas, everybody, and it might be tricky for that to be the case and to squeeze it in this year. So it may be that it's the Employment Rights Act 2026 that we're looking at. And again, we'll talk a little bit in the next few slides about whether we think the timeline that the roadmap document that the government set out, whether the timeline in that might be impacted by the delay in actually this becoming law. And it feels like, you know, that's likely, but again, we can't be 100% sure on that. So in terms of the timeline itself, from the government's roadmap document, that was released in July 2025, so July this year. So obviously that's a little while ago in itself. And it set out a number of things and the dates by which the government wanted to implement them. Lots of the stuff that they wanted to get in quickly related to union activities, and you can see some of that stuff on the slide. But of course, lots of this stuff's been delayed as a result of the bill not becoming law yet. In terms of looking at next year, again, I'm not going to read through them all on the slide. You can have a look at the detail of that, but I will highlight a few of those. The SSP changes we're going to talk about later in the session. I think that's a significant one, and one that they might be able to actually implement April next year. And they've already started work on the Fair Work Agency, which is an agency that they're setting up to combine the functions of some other organisations, government bodies, but will essentially be designed to enforce certain things like holiday pay, national minimum wage, all that kind of stuff, we think. And I believe that they've appointed a head of that agency already, so work appears to be underway to get that up and running too. So it may well be that the April deadline is possible on some of that stuff, but we'll have to keep our eyes out and see. Then we're looking into October 2026, and you'll see there unfair dismissal changes ? Now James has on his slide unfair dismissal changes ? for 2027. And that's because we're not quite sure when the unfair dismissal changes might be implemented, and I'll touch on that in the next section in a bit more detail. Ban on fire and rehire is another one just to highlight there. And then there's obviously the stuff around harassment, which again, they were aiming for October 26. And I think at this point, I'm going to hand over to James because he's going to pick up the rest of that timeline before I talk to you about unfair dismissal.
Yes, thanks. Thanks, Nick. You can flick the slide.
Yeah, of course.
2027. And as Nick mentioned, and morning everyone. Most of you know me, as Nick alluded to, I'm also a director in our team, and as Nick said, sharing the load between us in the absence of Laura this morning. But the unfair dismissal changes Nick's touched on, when will they come into force? It's not entirely clear. Maybe next week, when this gets back to the Commons, the picture will become clearer. I'm going to talk later on in a bit more detail about the change to the duty to consult under TOCRA and when it's triggered. That's when the strengthened flexible work rights are scheduled to come in, as are greater protections from dismissal for pregnant workers, although the detail on that is scant at this point, which sort of leads appropriately to the next slide, which is, I know I'm one too far ahead of myself. A few more things in 2027, statutory right to bereavement leave, that also links to the next slide. Gender pay gap and menopause action plans, and the guaranteed hours offer rights to come into force. I've actually got a whole separate slide on that in a minute. Perhaps that should also have a question mark in it, but maybe that's a controversial statement. I'll come back to that in a second. The next slide I was alluding to is consultations. There's been lots of talk about consultations, and I think I heard one figure said there's 20 odd more planned, which just seems remarkable. So what I actually looked at was what consultations are actually ongoing. 4, it would seem, and they're listed on the slide. My sort of thought on that when I reviewed them was that wasn't hugely critical areas. It's not the big headline, big ticket items of the bill. Clearly, the unfair dismissal one is probably not needed anymore, given the move to the 6 months that Nick is going to touch on in a minute. So I think it's more watch this space on the consultations, but things that seem ripe for further consultation are the guaranteed hours, low hours, 0 hours changes, given the generally underwhelming reception to the bill so far from most sides. The collective consultation thresholds, although they've set out that it's changing, the actual key detail is in non-existent regulations. So that seems right for consultation to see where to actually pitch the extension of that right. And I've definitely read about consultation that's planned for the new third-party harassment in the Equality Act. I say new, those of you that remember the original Equality Act remember that there was third-party harassment, but the new third-party harassment that's coming back is going to be slightly different. And the consultation, as I understand, going to focus on reasonable steps and what that entails and whether things are going to be prescribed as reasonable rather than the current sort of existing Equality Act case law. The concept of all reasonable steps already exists in terms of a defence to the claims, but there's no sort of prescribed steps as such. What's a reasonable step in any given case can be argued each time. So as I say, further consultations follow. Watch this space, and now I'm going to hand back to Nick, who's going to do the main topic of the day, unfair dismissal.
Thanks, James. So, getting ready for day one unfair dismissal. Of course, we all were planning to get ready for day one unfair dismissal, but it turned out that Keir had another plan for change, or maybe didn't plan to change, but essentially the change came as a result of pressure from the House of Lords, and I suppose business lobbying groups potentially as well. And that's, I guess, the most recent development in the long and winding story of the Employment Rights Bill and day one unfair dismissal rights, which essentially has been scrapped as far as we can tell. And we think next week we'll get some more detail as to what the government are actually planning here. But what we can kind of piece together as it stands is that day one unfair dismissal rights will be scrapped. So there won't be day one protection from unfair dismissal as the government had proposed as part of their manifesto prior to the election. And therefore, instead, we will have unfair dismissal protection from 6 months service as opposed to the 2 years that you currently have to have in order to get that protection and be able to bring an unfair dismissal claim. The other thing that will disappear is this concept of initial period of employment, which was designed to be a sort of light touch dismissal process that you would have to follow during a period of time when the person first started working if you wanted to avoid an unfair dismissal claim. But again, we had very little detail on what that would actually have involved, and James did a good blog recently about the fact that that is likely, like some other concepts that were proposed in employment law, it will disappear into the annals of time, or whatever, however James put it, as a thing that might have been, but doesn't look like it will be the case anymore. So it's an interesting shift, I think. Those of you that have been around doing this stuff long enough will remember that we used to have a 1 year unfair dismissal kind of marker for protection. It was then increased to 2, and it looks like we're now going back down to 6 months. And I think that, the gist of this is that it will give many more people protection from unfair dismissal much quicker. I think the estimates are something like 6 million people, additional people will get that protection. So it is significant, and I think the thinking is that Angela Rayner will table amendments to sort of propose all of this on the 8th of December. The other thing that has been floated, and again we don't know for sure, but has been suggested, is that rather than this all coming into force in 2027, which we believe was likely a delay in order to allow business to get used to the idea and prepare for this change over a period of time, that there is some thinking that this might well be implemented next year. It's much more straightforward for them to implement because the law doesn't really change in quite the same way. And in fact, those of you that have been following our updates for a while will know that the government could have used existing legislation just to reduce the timescales from 2 years to 6 months. What they're actually doing is, we think, proposing primary legislation, so essentially legislation that it's more difficult for future governments to change, essentially. So we think that they're going to do it that way and reduce it down to 6 months without using the existing powers that they have to do that in order to make it more difficult to change moving forward. And then the other thing that, again, there's kind of rumors and bits of information about is the potential for them to remove or change the cap on unfair dismissal compensation. And again, we have to be slightly careful here that, there's talk about, well, there was somebody in a room with a minister who was talking about it and it was proposed, and then they commented on a LinkedIn post and they said that this might happen and so on. So until we have the detail, it's tricky to say. I think that there's enough out there to suggest that something might happen. I don't get the impression that they're going to do away with a cap on unfair dismissal compensation altogether, but it may be that we have some time at the end for James and I just to debate the whole unfair dismissal thing a little bit, because we do think that the move to 6 months will have some pretty serious impacts in terms of how you need to manage probation periods, for example, and the impact that might have and how people might get caught out. So I'm going to kind of save that to the end as a little teaser for us in terms of talking about the practicalities. Certainly, lots of the stuff that we were talking about previously when we thought it was going to be day one rights still apply in terms of what you might be looking to do in terms of preparation. And things like managing probation periods well, performance managing people well, training managers to deal with these kinds of situations much earlier are going to be absolutely key, because there's going to be a much shorter period of time for employers to decide whether the person is working out, essentially, if they want to avoid the risk of unfair dismissal claims. Now, obviously, you can let someone hit that mark and still dismiss them fairly if they're not working out for whatever reason, but it does increase the risk. And obviously, if you do that process properly and you have a fair reason, even if they do have unfair dismissal rights, then that minimizes risk considerably. But it's hard to see how this won't encourage employers to be looking at whether they need employees in that first 6 months period, probably, and a little bit of a spoiler as to the teaser at the end, probably much earlier than that. And that might be one of the unintended consequences of this, where actually we think we're giving people improved rights when actually they end up getting dismissed much more quickly than they would have done previously, because employers are concerned about unfair dismissal risk from the 6 months point onwards. So let's save some of that towards the end. I know we're getting some reports about James's sound. I would suggest just moving your microphone closer to your mouth, James, if you can. That might help a little bit. That's probably the best we can do. So I'm going to hand over to James, and we're going to talk about fire and rehire.
Thanks, Nick. No, it should be better now for everyone. It was nothing to do with the microphone. It was because my webcam packed in 2 minutes before the call. We swapped out, and it turned out I had the sound settings wrong, so you could hear me via the webcam, not via the headset.
That does sound better.
So we should be all better now. Fire and rehire, as Nick mentioned, possibly one of the more important parts of the bill, in that it seems to have a real practical impact potentially. And because there's been little change on a lot of the bill, this seemed an area worth going into a little bit more detail on, because I'm going to jinx it now. This bit seems fairly settled and is mostly clear from the law as we have it. So I'm going to go into a bit of detail as to what it will actually mean, assuming they don't change it any further, which I think is a fairly safe bet. It's no longer a complete ban, which some people have sort of commented on negatively from they've dropped the proposal in the same way as unfair dismissal. But to me, that seems very churlish, because from an employee perspective, it's still very favourable towards employees and very prohibitive towards employers. So what does it mean? How will it actually work? Well, subject to a financial difficulties exception, which will be a very limited exception for reasons I'll come on to in a second, what the law will be is the fire rehire laws. It will introduce a new automatic unfair dismissal scenario, or actually a few new automatic unfair dismissals. So some of you will already be familiar with that it's automatically unfair if the reason or principal reason for dismissing someone is because they, say, made a whistleblowing disclosure. And this will work in a similar way, but just in different scenarios. So it will be automatically unfair for an employer to dismiss an employee where the reason or principal reason is that the employer sought to vary the contract of an employee to make a so-called restricted variation, and the employee didn't agree. Or, kind of the same thing, the employer sought to make a number of variations, and the employee did not agree to the variations, and within those variations there was a restricted variation. So it doesn't apply to all fire and rehire. There's this concept of the restricted variation. Now, that's just variations. To ensure there were no loopholes, they've actually created 3 separate, sort of, in some ways, slightly overlapping scenarios where there'd be an automatically unfair dismissal. So bear with me. It's also automatically unfair where the reason or principal reason is to enable the employer to employ another person or just re-engage the employee who they've dismissed under a varied contract to carry out the same or substantially the same duties as the employee carried out before they were dismissed, provided that the varied contract includes a restricted variation. So again, a lot of scenarios, you could argue that one or both of those will apply, possibly both. So that's the classic fire and rehire. But this all stems back, for those of you that have been listening to me talk about this for years and years, to that P&O case that was always known as the fire and rehire case, but ironically didn't include any rehiring. They replaced the fired people with third parties, I think it was agency workers abroad. So what this bill does is introduce a specific prohibition on fire and replace, again, by making something an automatic unfair dismissal. And that's where an employee was employed, and the reason or principal reason they were dismissed was to enable the employer to replace that employee with an individual who is not an employee of the employer, subject to some conditions. The conditions are that the contract with the replacement individual or individuals is to carry out activities. The activities that the replacement is employed or not employed is engaged to carry out are the same or substantially the same as those that the dismissed employee carried out, and that the dismissal is not attributable to a reduction in the requirement or the respected requirement for the employer to have those activities carried out. Now, that third caveat was a somewhat waffly phrase that you might be familiar with from Section 139 of the Employment Rights Act. It essentially replicates a redundancy situation. So you would be able to make employees redundant and hire someone else to carry out those activities if the reason you wanted to make the employee redundant was a genuine redundancy situation. So the requirement for that work had ceased or diminished or was expected to cease or diminish. So quite narrow exception. So that's the three things you can't do: fire and rehire, just fire because they won't agree the change, or fire and replace. Beggars the question then, what is a restricted variation? We do have a bit of detail as to what that is. So it's not every contractual change you might want to make, but it's most of the good ones. So if you wanted to vary terms relating to pay and performance, so the obvious things, salary and wages, the legislation has clarified that this would be restricted variation would include pay linked to the amount of work done, or pay that's referenced or measurable reference to results achieved by the worker. Pay and performance includes any term or condition relating to pension or pension schemes. That's in the restricted group. Hours of work and holiday terms, so working hours requirement. If an employee does X hours per week and you wanted to change it, that's a restricted variation. This next one's a classic Employment Rights Bill category. A restricted variation includes the timing or duration of a shift which meets conditions set out in regulations. So those regulations don't exist, so I can't tell you what that means, but it means that they want there to be scope to make it difficult for employers to amend the timing or duration of shifts for employees or workers. And holiday, any attempt to reduce time off. The legislation refers to time off rather than holiday, so whether that could be broader than I'm working out holiday. Somebody said annual pay reviews. Will that come into this scenario? If the change was to go down in pay, then yes. Nobody's going to sue for having their pay increased, I'm fairly confident of. And then the final category, variation clauses. So you won't be allowed to vary contracts, to introduce a new right to vary any of the restricted clauses. I mean, that's a fairly sensible anti-avoidance provision. It would render the whole thing moot if you could do that. And then finally, in case the government has missed anything, you can't vary anything else that they may subsequently specify in regulations. So I alluded to earlier the exception to all this. So when you can actually make restricted variations and you can avoid all of those automatically unfair dismissal scenarios that I outlined, it's where the financial difficulties exception applies. What does that mean? Well, there'll be no automatically unfair dismissal where the reason for the restricted variation was to, and this is a real mouthful, so bear with me, eliminate, prevent, or significantly reduce, or significantly mitigate the effect of financial difficulties, which, and I think this point is worth underlining, at the time of the dismissal, were likely in the immediate future to affect the employer's ability to carry on as a going concern. Now, whilst I can see there might be a lot of argument in the employment tribunal about that, it seems like it's going to be a big uphill struggle for an employer to ever meet that condition. You almost wonder whether if you got to the employment tribunal and you're in that, you could meet that condition. By the point you got there, you'd financial difficulties would have overrun you. So you have to meet that condition, or there is a slight difference in the public sector. In the public sector, the financial sustainability of the employer's ability to carry out their statutory functions is what the test is. And then if you can meet those difficult tests, you then have to establish that you could not reasonably have avoided the need to make the variation. So a real uphill battle. And I don't think it's one that's going to be able to be relied upon by employers very often, unless they're in really dire straits. And just to add the icing on the cake for employers, in the perhaps unlikely event that you met both of those conditions of the financial difficulties exception, you could still lose an unfair dismissal on the normal fairness principles, for example, by not following the new code on fire and rehire, or for any of the reasons you currently could under the existing legislation. So it's going to be very, very difficult to defend a fire and rehire based on those defences. So in light of all that, what should you do now? Well, the funny thing is nothing in that legislation prevents employers from relying on existing variation clauses. Whilst it's a restricted variation to add in a new variation clause that allows you to amend a restricted area, there's nothing so far that suggests that ones you already have couldn't still work. Now, I would temper that excitement by saying there's already a whole raft of case law about the extent to which variation clauses work. But having said that, it is very common for there to be clauses around adjustment to bonus terms, perhaps, and the ability to change the scheme, or to, for example, remove things like contractual benefits, although having said that, some contractual benefits sound like they won't be within the scope of restrictive variation based on the analysis of the provisions as they exist that I just did. So you might want to consider updating contracts in that way. Another thing you might want to do is change terms before the ban comes into force. So get ahead of the game. You aren't home and hose, because although it won't be an automatically unfair dismissal and you won't have to navigate the extremely tricky financial exemption, you still do have the existing law to grapple with. So it's not easy, and you might be, for example, if you're doing it with lots of people, subject to the requirement to collectively consult. So it's no easy game changing terms and conditions on a large scale, but it might be worth doing if you fear that this is going to cause you big difficulties. The other practical step that I thought was worth flagging is trying to be ahead of the game of where disputes are likely to arise. So custom and practice is a classic one. If your contracts don't reflect what's actually happening, do we need to be clear in the contracts as to what the intention of agreement is? Because it's always a good argument if you're saying someone's trying to argue a implied term, and you can say, well, but we've got an express term that contradicts that. How can it possibly have been intended for us to agree that when our contract says the exact opposite? And if you've introduced contracts relatively recently, it becomes more difficult for employees to say, but we've always done it this way, when 6 months prior they've signed an agreement that accepts that the term is something else. So think about where disputes are likely to arise, usually with custom and practice. I've seen in the chat there's talk about hybrid working and place of work, working from home. That is a classic avenue that's ripe for custom and practice style arguments. As I think Nick's already answered in the chat, that doesn't come within the scope of the restrictive variations I was talking about as the legislation is currently drafted. So you wouldn't have a fire and rehire scenario, but it is a ripe area for disputes. So whilst the practical steps I'm talking about are linked to the change in the law, it might be a good thing to tidy up while you're at it, if you want to make it clear whether people are working remotely as an absolute contractual right, or whether that's just a practice that you could amend or withdraw at any time. next section of today, because that's it for fire and rehire, you'll probably be pleased to hear, is other changes. And as Nick said, we unfortunately have to jump about a bit because there's lots of different stuff in the Employment Rights Bill. Tribunal time limits. Nick already beat me to plugging my own article on this exact area, which is on LinkedIn. The proposal is quite simple, really. It's just to change the existing law to go from 3 to 6 months for most claims. So from the point of dismissal for dismissal-related claims, and from the act complained of for things like discrimination or whistleblowing detriments. I suggested that I'm not convinced this is such a good idea for numerous reasons. One being the double whammy of the ACAS early conciliation extension. Those of you who are on the ball will know that it recently flipped over from 6 weeks to 12 weeks. And that of itself gives everyone 6 more weeks potentially to put in a claim in addition to the existing 3 months. If you double the 3 months and you add 12 weeks and you time it correctly, because you get the extra month from the conciliation ending if you start the conciliation in time, I think I worked out you had about 10 months or something ridiculous. I did an example. I worked out how long you could leave it and still be in time. And if you factor that into the fact that tribunal cases are already significantly delayed, and that's going to get worse and worse and worse, by upping the time limit, you could be looking at listings very soon into 2029. I think my record is the back end of 2028 at the moment for an existing tribunal that I'm working on. And it's you would think the time limits plus the unfair dismissal changes is just going to be fairly disastrous for case progression. And the roadmap says that these time limit changes are due to take place from 2026. I think I'm going to hand back to Nick now.
Thanks, James. I think you're going to keep control of the slides so that we don't have to chop and change too much. So if you wouldn't mind moving it on COVID style. Next slide, please. Thank you. I also was partway through answering another question in the chat. So James, I might leave that one to you so that I can talk about flexible working. And again, ahead of this bill and ahead of the Labour government coming into power, there was lots and lots and lots of talk about flexible working and how they believed that flexible working was super important, and that they wanted the workforce to be able to do more in terms of flexibility and so on. And obviously COVID had a massive impact on the way that people are working and the flexibility that many of us now enjoy. And there were a whole load of different provisions, things like the right to switch off, where we were all going to have our emails turned off at 5 p.m. and never have to work after that, and the right to disconnect, as it was called, and that kind of thing. And there was, I think, lots of talk about how flexible working legislation would change too. And there is a provision in the bill on this area, and there has been plenty of kind of academic or commentary about what it means and how it'll impact and that kind of thing. My personal view is that it's not very significant, and it probably won't have that much of an impact. And I'll explain why. I think essentially what it's doing is building in an additional sort of level of reasonableness, a word that we all know and love in employment law and in HR because it's so difficult to work out what it actually means. But a new level of reasonableness in terms of the grounds for, the reasons behind, I suppose, rejecting a flexible working request. So that request must be reasonable, as the new law provides, but it still is rejected on the basis of the 8 statutory reasons that are set out in legislation. Again, you'll be familiar with those, I'm sure, and we have to kind of shoehorn our reason for rejecting the request into one of those reasons, or in fact a number of them. That will remain the same, but this additional sort of it must be reasonable sort of element is introduced too. And I think for me, that doesn't really add that much. Most of the time, employers who are doing the right thing and engaging with their workforce as to why they're rejecting a flexible working request will generally provide some information as to why that is, and won't just simply state the statutory reason. They'll talk to the employee about why it won't work on the basis that they've proposed, and they'll explain the impact on the team or the business or the reasons behind it, and explain why it's reasonable, they believe, for them to reject it. So I'm not sure it necessarily changes that much. There is talk about additional elements to this being introduced via regulations, and it may even, result in a sort of new procedure for dealing with these kinds of requests. And the delay that we're seeing with all of this implementation of the bill, as a whole, might well allow for further consultation on this area as well. So it's kind of watch this space. I'm not convinced at the minute in its current form it really will have that big an impact, particularly for employers that are already doing this stuff well. James.
Thanks, Nick. Back to guaranteed hours and reasonable notice of work schedules. Now, you'll probably be pleased to hear, after I just talked about the fairly technical changes to fire and rehire, that I don't plan to go through this in detail for a few reasons. I mean, I'll just remind everyone of the background. Essentially, the idea behind this was to stop the abuse of 0 hours contracts, as it was described, by introducing a right to employees to be offered guaranteed numbers of hours to 0 hours workers based on an average, we've assumed, I think the legislation does say that, over a reference period which has never been defined, but everyone's always assumed is going to be 12. And it also, the legislation introduced this concept of a low hours worker, which isn't a 0 hours worker, but it's someone who has a set number of hours that is low. And because where you set that bar of low is so absolutely critical as to whether this legislation will be really employee friendly or really not so useful. I suppose it's always going to be employee friendly to a certain extent, but if you set the low hours bar quite low, it won't be as useful to the employees as you would think. I think everyone is too scared to say what the low hours is. And so that's something that nobody's ever told us and still doesn't exist. And since we last talked about this area, nothing has really changed. I'm starting to become quite, I don't know, cynical, skeptical, I'm not sure what the right word is, that this is going to go the way of the light touch unfair dismissal during the initial period of employment and just go in the employment law dustbin. Maybe it will come into force, but the difficulty that everyone is highlighting, which I think is a really good criticism, is if lawyers like us are spending hours reading it and finding it difficult to follow, how on earth are employers and, more importantly, employees going to be able to follow this? It's just going to be very, very difficult. And the consultation that is upcoming is surely going to be aimed at trying to make it simpler, or at least set out a framework of how everyone's going to expect it to work. And my sort of slightly negative viewpoint is that that's going to drag on for so long that it might get to the point where the government changes and they decide, actually, we're never going to implement that. So I'm taking the view now that it probably isn't the best focus to talk about this in the detail, because what seems fairly certain is that it's not going to come in for a long time. Well, he says a long time, at least a year. And so if it does come back, we can withhold going into the detail nearer the time when we're going to be gearing up for this, and hopefully there'll be a sufficient lag between when the detail as to how it's going to work and the key points about what the reference period is and what a low hours contract is, and the regulations that are needed to make the drafting in the bill work will come to life. So that's all I want to say this morning on that. It could be the topic of a future seminar. Some of you might want to duck out of that one. Others will probably be very keen, depending on the industry.
Thanks, James. Thanks, James. Yeah, I was talking to a people director yesterday who was saying the same, that they thought it probably would be too complicated and that the government might eventually give up on it. But it may well be that they were just wishful thinking on the basis that it would have such an impact on their business. But we'll see. Again, jumping around because the bill jumps around. Onto menopause action plans. So this is a provision which would require eventually employers with more than 250 employees to publish menopause action plans. That's part of something that they're describing as wider equality action plans, that there would be penalties for not doing that. Unfortunately, a bit like lots of other areas of the bill, we don't yet have the details as to what the menopause action plan would be required to contain and how often they would be published. But we do know that, again, the government was aiming for, and again, we'll see whether the timeline is maintained, but aiming for these to be voluntary for employers by April 26 and compulsory in 2027. What I can say is that just last week, I did a webinar on the topic of menopause with Angela Wilkins-Green. So I know some of you were along to that. If you missed it, again, the QR code link there will take you to that session, and you'll be able to watch back if you would like to. James may need to move that slide on. I've forgotten that I was not in control and moved my own on. So it may be that I'm seeing it and you're not, but I'm sure James will have done so. There is a QR code, and that will take you to, I think, a YouTube version of that webinar. What we talk about as part of that is the kinds of things that might well be in those menopause action plans. So some thoughts ahead of actually knowing the detail as to the kinds of things that might go into it. So hopefully that's useful. You can skip through to that section, if that's particularly relevant, but it was I think a useful webinar overall if you missed it, and it will just give you an idea. I think some employers are already implementing these kind of things already, even before April, because it's useful to, and therefore it may well be that you want to get ahead of the game on that too. And I think that's back to James.
Thanks, Nick. Changes to collective consultation. For regular attendees, you'll be pleased to hear I've not updated this because the bill is largely as you were. So the proposal, just to remind everyone, from 2077, the duty to consult under the Trade Union Labour Relation Consolidation Act will be extended. The first bullet point on the slide is when the existing duty is triggered. The extension is when some other threshold test is met. The key thing in the new threshold test is that it will be assessed across the employer, as opposed to the first bullet point. The key word, and often subject to a bit of argument, is at one establishment. So it's more of a joined up threshold. So it could be, I assume that it would be a lower number to factor in the aggregation. And what the changes in the law to the Act are largely around making the second bullet point practical. So I think in a previous webinar before we had the detail, I talked about employee representatives being all across the country and how it might be a bit ridiculous to have meetings, and how could you agree things when everyone's all scattered around. And the new legislation actually does address these issues. So you wouldn't have to meet all the employee representatives at once. You could do it by site or establishment. And similarly, the collective consultation is with a view to reaching agreement. The legislation is clear that you could reach agreement to apply in one area of the business and not another, where the duty to consult is being triggered collectively. So some sensible practical points have been made in the legislation. So that shouldn't be too bad. But the key thing of when does the new threshold apply, that hasn't been set out yet. And that's likely to be one of the things that there's, to bandy around the word consultation in the context of the government consulting wider groups rather than the doing it in your own employment scenario context. So there'll be more consultation on that, and hopefully we'll become clearer. And to align with the strengthening of the right, as the last bullet point says, the protective award is going up. So it'll be even more important to get this right once they've changed it than it currently is, although I think the current protective award is a fairly good deterrent, it being potentially quite costly. SSP, Nick.
Thanks, James. Yeah, another one potentially landing with us in April next year, which obviously will come around fairly quickly. The the headlines around this change are twofold, I suppose. The first is that statutory sick pay will be payable from day one of sickness, as opposed to having the 3 waiting days that we have at the minute. So increasing the cost for employers on funding that, potentially, depending on your view, increasing the likelihood that people will take sick leave. Again, it may be one of those unintended consequences. But also increasing the number of people that will be entitled to statutory sick pay by removing the lower earnings limit, which is currently £123, and therefore meaning that more people qualify for SSP. We think that it's likely that the percentage that will be applicable in that circumstance, i.e. how much money they will get, will be 80% of their earnings. So they're a low earner anyway, and then they will get 80% of that as part of SSP. So again, lots of employers are planning for this, and the way they're doing that is talking to their finance colleagues as to the potential financial impact of the changes, i.e. more cost. But the other thing that they're doing is seeking to improve their absence procedures to avoid people being off in the first place, or managing absence well if they do end up going off. And there's something that I'll highlight to you at the end of the session as to how we can help with that. So it's definitely an area to focus on pretty quickly, and if you haven't already, be flagging it to your finance colleagues. James.
Thanks, Nick. Fairly quick one on pay reporting, and the science sets out the basic detail of that. From what I've read, to help organisations who have to do this, the way you report your equality action plan will be through the existing report you'll already be doing if you qualify as an organisation to do gender pay gap reporting. And the government do say they're going to be releasing new guidance on what it is you need to say, which is the steps that you've taken to reduce the risk or prevalence of sexual harassment. But there's always a kicker with this. Although there will be support and guidance and a portal for doing it, there is also going to be a naming and shaming mechanism for those that don't comply. So it is something to keep an eye on as and when it comes in, just to make sure your reporting is now including all the things that it needs to when that's extended. Then finally back to Nick, and then we'll get onto a bit of a debate on the unfair dismissal.
Thanks, James. So just to finish, we thought we would just highlight some of the practical things that you might be thinking about or wanting to think about now. Hopefully you've picked up some of those as we've gone. But when it comes to the, I nearly said day one unfair dismissal rights, it's not likely to be that. When it comes to the new 6-month unfair dismissal provisions, we're going to be looking at probation periods, performance management, and I think some employers, we certainly heard of employers that were doing this at the point that day one rights were announced quite some time ago, looking at the workforce and deciding whether they need everybody, and they were dismissing people because they thought that employees were going to get day one rights pretty quickly, which of course has not turned out to be the case. But actually actively looking at your workforce and thinking, are these the people we need? Are we performance managing them properly? And do we need to look at restructuring in some way? Might well be a good idea at this stage. James highlighted the fire and rehire provisions, which is the kind of what I describe as the end point or the worst case scenario should you end up needing to do that as part of a process of changing terms and conditions. And one of the things that James obviously quite rightly highlighted was maybe you should look at whether you want to change those terms and conditions now ahead of this legislation coming in. And that's why we've highlighted that one, because a lot of clients do say to us, oh, we don't do fire and rehire, therefore it's not relevant, is it? And of course, that's missing the fact that it's the kind of worst case scenario. If you have to force a change through because people won't agree it, then actually it might end up being something that you do want to do and may be prevented in doing it in certain circumstances once this becomes law. Preparing for those equality action plans and menopause reporting. Again, we have a number of clients who are getting ahead on that because they just think it's good for their workforce, for their employee brand or employer brand, I should say, and so on. So that's definitely, you know, something that you could be thinking about. And then factoring in the cost of these changes. It feels like, you know, employers are getting a pretty hard time at the minute when it comes to budget changes, but also some of these changes in the Employment Rights Bill will have a financial impact, and therefore we need to, you know, be modeling for that change into the future so that we're on top of those things from a financial perspective as well. So super important to be thinking about that. I'm just going to skip ahead slightly and talk to you about the absence thing, and then we'll come back for questions. So something totally different, but linked to the SSP point. We are offering something called a sickness absence audit. And essentially, this is designed to help employers manage absence better. We do a lot of that work with clients, but with the SSP changes coming, we think it's going to come into focus. You know, the fact that people are off more, as I suspect will happen as a result of those changes. So what we're looking at is reviewing sickness absence procedures, capability processes, what we have in our employment contract and our documentation in terms of managing absence well, and giving power to employers to do that in a way that's helpful. Also, what managers do with absence at the point it happens. And reviewing all of that and essentially producing a report, which then allows an employer to improve those things. So recommendations for improvement, looking at how we might tailor those absence processes to help reduce absence related cost across the business. Obviously also looking at any legal gaps that there might be there in terms of, you know, discrimination risk and all that kind of stuff. So if that would be of interest to you, again, another QR code, apologies, but hopefully they're working okay for you. You can scan that QR code. It will take you to the webpage with some more detail. Yvette has very kindly put a link in the chat as well. And it'll also allow you just to book in for a short, no obligation sort of free chat with me to understand how we might be able to help with that audit. So we think this is going to become even more important as lots of these provisions in the Employment Rights Bill kick in, and we're all need to manage our people better, shall we say. I've got a comment in the chat as well about slides. We don't send the slides out, but we do send a recording by email of the entire session for everybody that signed up or attended. So you'll be able to watch that back at your leisure. So any other questions before we finish? We're very happy to take those. If there aren't, or in fact, in order to give you some time to think about them, I'm going to ask James a question, which is, James, talk to us about our discussion around that we had yesterday around probation periods and people getting caught out with unfair dismissal with the new
Yes.
six-month rules.
So the thing I'm envisaging that's going to go disastrously wrong for a number of employers is a lot of employers will have in their contracts something along the lines of your probationary period is 3 or 6 months, or if it's 3 months, it can extend to 6 months and we can give you a month's notice. And I just see this scenario where employee starts on day 1, 1st of January. I won't do a year because who knows when all this law will change. But in a world where there's 6-month unfair dismissal protection, day 1 you start, 1st of January, and then on, say, 25th of June, Nick calls me in, I'm the employee. Nick calls me in, it's not working out, James, you've been rubbish. I'm dismissing you. Probationary period. I'll pay you a yearly notice. Here's your box. And I think, haha, yes, unfair dismissal. Thank you very much. Because although I'm in my 6 months and although I'm in my probationary period and although he's paid me in lieu of notice, he's not complied with the ACAS code. And although he's dismissed me on the 25th of June, I go, haha, my effective date of termination is 1 week later, because I get to add on my minimum statutory notice, and now my employment effectively ended in July, so I've got my 6 months notice. So 6 months probationary period is going to lead to problems, because if people do it right on the button, even within the 6 months, you might tick over into having your service to bring your unfair dismissal claim. So I don't know whether the solution is just have maximum 5 months or 5 months, 2 weeks. you also see contracts where it says if you're off sick during the probation period, we'll extend it for that length of time. That'll work as a matter of contract, but you again run the risk of somebody having the 6-month service or being deemed to when you add the extra week. It was a relic of me being old enough to remember when it was 1 year unfair dismissal, and you were always dead worried if you got to 51 weeks because of the extra week you'd add on. And I can just see a whole load of cases where everyone's arguing both the start and end date because it's 6 months is such a short time. An odd day here or there is going to make all the difference between someone having the right to bring an unfair dismissal claim and not. So there could be a contracts on start date, end date, and keeping a record of when people started. It's going to be all the more critical. When you've got 2 years to play with, it's easier.
Yeah, and I think even with 3-month probation periods, they're very commonly extended, aren't they? Oh, well, we'll give it another 3, or we'll give it even a month. Oh, but it's going to be a rolling month, and we can quite easily see people, slipping towards that 6-month mark very easily, and getting caught out. So again, I think that's part of the reason that we may see people getting dismissed at the end of probation much more readily than perhaps we would have done before, because employers will be concerned about extending a probation where they might have done previously, and not doing it this time.
And I can see also a revisit to the case law around, it's a bit old-fashioned, the old postal rule about when people can reasonably read a letter that you've posted them telling them they're dismissed, because you can see there's going to be more and more situations where you've got your probationary period, you've been up to speed, you've worried about my extra week problem, you know exactly when you need to dismiss them by, and then lo and behold, on the day of the meeting, they go sick. And you're desperately trying to effect a dismissal. And it's, a horrible scenario where you're sending emails, trying to phone people up to make sure they know they're dismissed. So there's no argument about whether they've reached the threshold. So yeah, I can just see panics and problems and some of the sort of case law that doesn't come off as much under the 2-year rule rearing its ugly head.
Yeah. Yeah. We've got a question, James, in the chat, which says, we don't have probationary periods. Do you think the new changes will stipulate that they will be, they'll need to be in a contract, in a clause in the contract? We haven't seen anything, and James, correct me if you have, we haven't seen anything that would be the case. It's almost, the question's almost a bit like the old initial period of employment, which was kind of like a probationary period, but not. And yeah. I think, I can't see that there will be anything along those lines. It'll be the 6-month mark, I would think.
Yeah, although the only thing to bear in mind is that the law already does say that any terms relating to probationary periods need to be in the contract. So yeah, it's fine if you don't have one to not have any terms in the contract about it. But if you do, it's mandatory that it's in the contract.
Yeah, yeah. Yeah, that makes sense. Okay, anybody else? We've got a little bit of time.
I mean, the other area of debate, if we're waiting for questions, is there's a lot of hope, I suppose, that this unfair dismissal change isn't going to completely ruin the tribunal service with millions more unfair dismissal claims. And what's going to happen is that people are going to help the tribunal service by, instead of pursuing discrimination claims inside 2 years, they're going to put in unfair dismissal claims, which are listed for 1 or 2 days rather than 3 or 4 or 5 days. Do attendees think that's really true? Are people going to just stick to unfair dismissal because they can? Or are we going to still see just as many discrimination claims and whistleblowing claims? I should add whistleblowing, because I see a lot of those. And often it seems, and when you get to the end, it's decided that in effect, the person was just upset about being dismissed and was basically arguing unfair dismissal, but badging it as something else because that was the only way they could have a claim. Is it going to help in that respect? I suspect the answer is probably a little bit. But...
Yeah. We've got another question, or a few more questions. So would a 5-month probation period be suggested where possible? I don't think we really have a view on how long a probation period should or shouldn't be. I suppose that's really for an employer to decide how long they need and is reasonable to decide whether somebody's working out or not. But what we're certainly saying is, don't leave it so late that you're running into difficulty because the person still is employed at the 6-month mark. Again, 3 months seems fairly common for a number of our clients, as well as 6, but I don't think 6 is going to work anymore for the reason that James has suggested. So I suppose the technical answer is less than 6 months, or five months and 3 weeks, or in reality. But I think I can see a lot of people moving to a 3-month probation period with the option of some extension, but not beyond a point which is going to cause difficulty. So we'll see. Let's see, is the 6 months protection coming in Northern Ireland? Do you know? I know they currently have 1 year. The honest answer is I don't know, because we don't cover Northern Ireland. What I do know is that there's an entirely separate process being looked at in terms of changes in Northern Ireland. So it's probably one for lawyers in that jurisdiction, because they have similar but actually quite different laws in Northern Ireland, which actually ironically is where I'm from originally. I don't see any changes due to the potential higher compensation of discrimination claims. Often the trade union will use this tactic.
That's a good point. I was thinking about that one, Nick, whilst you were talking. And
yeah.
I guess that's a really good point. One interesting factor that might impact the answer to that is what the change to the unfair dismissal cap is, assuming there is one. So if you did what a lot of commentators are saying and kept the overall compensatory cap, which is someone can tell me I'm wrong, because I'm probably wrong, but about 115, 120,000.
Yep.
But that is the higher of the two current caps. The cap is that, or 52 weeks pay calculated using the or 4 weeks pay calculation in the Employment Rights Act. If they got rid of the 52 weeks pay for a lower paid worker, the higher cap is going to be really high by comparison. So it might impact. So it'll probably depend on how much the person who's bringing the claim is paid as to how that factors in.
Yeah, and we were talking yesterday, James, weren't we, about the fact that removing a cap on unfair dismissal compensation altogether seems a strange one for lower paid earners, as in the government's policy or lots of the provisions tend to be focused on lower paid vulnerable workers, and actually lifting the £120,000 cap seems to achieve a position where higher earners would recover more for having been unfairly dismissed, as opposed to lower earners, because it's unusual that a low earner will get years and years and years and years worth of loss. So again, it would seem a slightly strange thing to do.
Yes, you could see how bankers could be clogging up the employment tribunal, arguing over extortionate salaries on the basis that their damages for unfair dismissal are now uncapped, and they could be lawyering up with highly expensive silks and clogging up the system. So it wouldn't seem to be fitting with the purpose of the rest of the bill to uncap it for the higher earners. Someone's put a really good question in: is it reasonable to end an employee's probation for the end of the period? Yeah, absolutely. Most contractual provisions, the probation period is essentially the maximum period, not the minimum period. But the irony, of course, is it reasonable? Well, if you fire someone for, say, poor performance within 6 months, and factoring in my extension of 1 week that I mentioned before, so assuming they haven't reached their unfair dismissal qualifying trigger of being deemed to have 6 months service, the beauty is it doesn't matter if it's reasonable. They can only argue whether it's reasonable or not after they get to the right to claim unfair dismissal. But that does create the moral dilemma of, are we not now creating a culture? I think I was suggesting this to Nick, or are we not in danger of creating a culture that the cautious approach is just to fire someone who may or may not be performing well? And you might end up losing people who, if you'd have sort of hung in there beyond the 6 months, could have blossomed to be really, really good. And nowadays you would probably have thought, well, let's see, we'll give them another 3 months, get to a year. If they're still not working out, it's still relatively easy to get rid of them. Is it actually going to create volatility and more claims rather than stability in employment? So is it going to have the opposite effect than perhaps the government wants, because employers are going to be too cautious? I don't know, but I can see that people are going to ring up risk-averse lawyers, and we're going to go, well, after you took over this date, it becomes a lot more difficult to fairly dismiss them. It's up to you. And then the employer is going to be...
Yeah, I think it's likely that that will be one of the consequences for sure. And yeah, for most of us, it's new ground, isn't it? The 1 year mark was a different situation as well, and I think resulted in more of that too. But 6 months pushes it right into that really short period of time for employers to decide whether someone is working out. And I think, yeah, I suspect there will be more of it. There'll be more dismissals as a result. I think we may be running out of questions. We've got some nice feedback, so thank you for saying thank you. It's been great to see everybody. Obviously, I've left the absence audit slide there. If you are interested in that, feel free to book in. We are likely back in January with our next webinar. We're going to take a Christmas break. And we will see everybody then, but we really appreciate all your support this year on our webinars, and it's been great. So have a great Christmas, and we will see you in the new year.